The most daunting aspect of a litigation is probably not what you think. It's not the filing of the complaint. It's not piecing together tedious documents to submit via discovery. It's not appearing for a deposition. And believe it or not, it's not even taking a witness stand at trial. It's the disturbing reality that if your business partner or a managing member of an LLC is committing fraud and essentially depleting the company bank account of liquidity and selling off the company assets, that you may wind up gaining a judgment at trial that essentially is worth nothing. Now, if you have reason to believe that your business partner is committing fraud, chances are you're probably right. So there are ways to protect yourself and not wind up in this position where you have nothing to account for. Before I speak any further and explain to you what you should do, if you find this topic to be interesting, please like, comment, and share this video with someone you think might find value in it. Now here's what you do. Of course you need to file a summons and complaint. Nobody would deny that. Once you initiate that action, however, it's imperative that you immediately file an order to show cause. Now, an order to show cause is an emergency application where you go to the court and ask for specific relief. Unlike a motion, where it's usually on 8 days notice, 16 days notice, or sometimes even beyond, and where the parties can adjourn it, an order to show cause puts a document in front of a judge and explains why the judge needs to bring the parties into court immediately so that they can hear the arguments of both sides and make a determination. Now, in that order to show cause, you're going to seek the following relief. Number one, a temporary restraining order, which essentially will, if you're seeking this relief, freeze the bank accounts of the business, but also encumber the fraudulent actor from assigning, encumbering, transferring, selling any of the assets belonging to the business. The secondary relief you're going to seek is a preliminary injunction. And here's the difference between the two. When you submit these papers to the judge, you're going to say, Your Honor, I've got evidence to show that we believe this actor is committing fraud, and so therefore we need to get before you immediately, and you need to tell the other party that they must come in to show why you shouldn't, at the very least, freeze everything right now while the litigation continues. It's called maintaining the status quo. So the plaintiff will come into court, they file a memorandum of law in favor of their arguments, they file an affidavit in support, they file affirmations attaching exhibits, so that way you can present to the judge all the reasons why you're entitled to this temporary restraining order. Now, the defense has an opportunity to come in as well. Usually this all happens very quickly, so that if the papers are signed by the judge, you could potentially get before a judge the same day, but typically it's within a couple of days thereafter. So since the defense is required to appear in court so quickly, they often don't have time to brief the matter, meaning they can't submit paperwork in support of their various arguments. So what winds up happening is the opposition comes in, the judge hears the arguments of both sides, and if you're able to obtain that temporary restraining order, which requires three things, by the way. Number one, showing that there's a likelihood of success on the merits of your case. Number two, showing that there will be irreparable harm if the judge doesn't freeze everything. And number three, showing that the balance of equities, meaning who's likely to get harmed more, is in favor of the plaintiff, then you're going to get the temporary restraining order. However, that's not permanent. So what the judge will then do, they'll assign a date, whether it's 2 weeks down the road or 2 months down the road, for the parties to come back. Usually it's about a month to 2 months. And the judge will say sometimes even a little longer. The judge will give the defense an opportunity to put in formal paperwork to argue against why there should not be a continuing of maintaining the status quo pending the outcome of the litigation. Now, if the plaintiff is smart, you're also going to want to have an opportunity to put in reply papers after the opposition papers are submitted. The CPLR, the New York statutes, do not actually mandate that the plaintiff has an opportunity to submit a reply, so you're going to want to ask for that relief. Once all the papers are submitted, you go back before the judge, this time more like a hearing. Sometimes you bring your witnesses down that can testify in accordance with the affidavits you submitted, and you make the case before the judge. Now, in the meantime, of course, you're pursuing your claims. You filed your complaints, so you're getting your claims ready, and perhaps you're even entering into discovery. However, if you're able to obtain the preliminary injunction, that essentially means that this actor will not be able to deplete the company bank accounts and will not be able to assign, sell, transfer, convey assets of the business until there is an outcome in the litigation. So having that serves two purposes. Number one, if you go to trial and you're successful, then yes, you're going to be able to attach whatever assets there are to essentially enforce your judgment. Number two, it's going to give you some leverage in negotiations to be able to say, look, you know you can't do anything, you're not going to get away with this, so why don't we have a conversation about a resolution and see if we can make something work. So if you found this to be helpful, I think it's an extraordinary tool and remedy to be able to use in the courts. Once again, like, comment, and share. And if you think somebody can gain benefit from this, share it with them. And if you have any questions, of course, as always, feel free to reach out.